Tenants can be difficult. Far more difficult can be subtenants. This is where your tenant decides they want to play landlord and lease the property to someone else. In today's video, I'm going to tell you the story of the subtenant who wasn't allowed back on the property, so she punched her way in. So this is an eviction that I dealt with years and years ago. I actually represented the tenants who were playing landlord with a subtenant. And so I'm not going to get too far into the details, but essentially the tenants decided that it would be a good idea to meet up with a friend from college. And they went out, had fun, and little did they know that that friend from college was in between situations. So, as friends sometimes do, they said, well, we've got space at our place. You are welcome to join us. Stay as long as you need. And boy, did she take them up on that offer. Soon she was there and had moved in. And little did they know, she had no intention of leaving. She kept saying that she was looking for spots, she was looking for work, she was new in town, and so she just needed a couple weeks. Well, a couple of weeks turned into a couple of months, and then things started getting weird. Not only did she start taking over the living space, redecorating here, moving stuff around over there, she began to get demanding. Her hosts were a little bit loud and they were not respecting her space. And so very quickly, this couple, who at first was just trying to help out a friend, was very, very annoyed. The truth was, they didn't even have an agreement, certainly not an agreement to pay rent, but they were stuck with her because she had done that one thing that gives occupants the right to stay on property. She had established residency. She'd done this by staying there long enough and essentially using that address as her home. She was receiving mail there, and whenever she went out and looked for jobs, she was using that address as her residence. So in the eyes of the law, she was an occupant residing there on the property as a subtenant. Even though there was no formal lease or any kind of agreement for her to pay rent, she became what's known as a tenant at will. Basically, a tenancy at will can be created when a party who has the authority to allow someone onto the premises simply says, you can stay for as long as I let you. And that's what happened here. There was a couch and someone who needed a place to stay, so they welcomed her in and let her stay on the couch. However, it eventually got to the point where they no longer wanted her there. But even after asking very nicely, she refused to leave. Well, these two even issued a written notice to vacate, demanding that the subtenant pack up her things and leave, but she refused to do it. Now, I want to make it crystal clear that the next few details in the story were things they did before I was ever involved. I certainly wouldn't ever advocate for this kind of self-help remedy because it can get pretty crazy. But their big plan was to wait for her to go out job hunting the next day, and they stayed back, gathered all of her things, put them in a couple of bags, and left them outside the door, figuring, hey, she doesn't have a lease to stay here, and we don't have a formal agreement, so we can just put her out. Just like that, lickety-split, no problem. Well, problem. When she arrived, she banged and banged and banged on the door. Things got so bad that someone else called the police, and sure enough, in short order, the police arrived. Now, my clients, the legitimate tenants, in this case, the sub-landlords, were inside the whole time. It's not like she couldn't recognize their car parked out in the parking area. She knew they were in there, and she was not going to leave until she got inside and made sure that she had all her stuff. Now, it was crystal clear they wanted her out. They'd given her a notice in writing, but they hadn't evicted her. And so by putting her things in a bag and setting them outside, they had locked her out. Technically, this is an illegal lockout. They didn't know, but that's what they did. And when the police arrived, they explained to the tenant that this was a civil matter that would have to be dealt with in the civil courts. Now she said, okay, well, if we're talking about the criminal law then, is there any criminal infraction for me entering the home at this time? And they said, if this is your residence, you are allowed to enter. Then she asked, can I use force to enter onto the property? And the police officer who was there said, well, technically, yes, but, and before he could get in another word, she punched the glass right beside the doorway. Now, the setup at this apartment was door and right beside it, a giant window. And she figured if I punch through the window, I can just walk in. I can crawl right through, get whatever remaining things are there, and then I can leave. And that's exactly what she did. She punched a hole clear through the glass, moved over the blinds, and entered the property. At that point, the door did open, and my client stepped out, shocked and confused by what they had just seen. When they argued with the police officers explained she has every right to enter even by force if this is her residence. She claims she lives here. Does she? When they explained that she was a guest who had been there for a few weeks, the police officer said, look, I don't make that call. That's up to the courts. If she's been living here, she has a right to enter and she cannot be locked out. And the police officer is right. By prohibiting someone from coming onto the property, you have just committed an illegal lockout. And it doesn't matter whether you are the apartment manager landlord or the landlord in this subtenant sort of arrangement, you're held by the same rules of the law. If you're acting like a landlord, you're going to be held to the standard of a landlord. And a court can issue a writ of re-entry, which is what would have been appropriate if the subtenant, the couch surfer, had gone to the court and had sought a writ of re-entry. The court would have forced my clients, the tenants, to let her back in. However, that's not what happened this evening. She was so upset, she didn't want to stay. She just wanted to make sure she got all of her belongings. But she did it in the most dramatic way that she didn't actually accomplish her goal, because immediately what everybody noticed was through the apartment was a trail of blood. When the girl punched the glass, she cut her arm in such a way that blood was splattering everywhere. It was up and down the carpet, it was all over the window, and when she stepped outside to explain herself to the cops further, it was all over the sidewalk. Her bags were covered in blood. It was an absolute biohazard. But remember, she had the right to be there. However, the police strongly urged her to seek medical attention. And in fact, an ambulance was called because she was bleeding so profusely. She was walked downstairs when she volunteered to go visit the ambulance, and she was eventually taken to the hospital. Now her stuff remained right there, right outside the door, covered in blood, as was the sidewalk, as was that path inside the apartment. It was an absolute mess, and neither the cops nor my clients wanted anything to do with anything that was left there. In fact, before she left, she told everybody, if you touch my stuff, I'm gonna sue the pants off of you. And downstairs she went to the ambulance and eventually to the hospital. Now, the very next day, my clients went to work as they normally did. And when they came back, they found no blood and a repaired window. Maintenance had come by, replaced the broken window, charged my clients for it, and cleaned out the sidewalk. They had used whatever chemicals they used to get rid of all of the blood. Unfortunately, they also took away the 2 bags full of the belongings of the occupant. So that later, when she returned, a whole week later, demanding her stuff, there was no stuff to give her, and my clients had no idea where it was. All they knew is they went to work, they came back. She told them not to touch her things, and they didn't. So when she returned, everything was gone. How did I get involved? Well, she later sued my clients as her landlords and said that they owed her the value of all the things she had left in those bags. And we dealt with this case for months before we finally were able to resolve it. So can a tenant come back and sue you if it turns out that their stuff is missing? Well, it depends on the facts. In this case, the tenant left her things outside in the open air. My clients had no duty to care for her personal property if left out in this way. In fact, if they had taken the liberty of moving her personal property into the home in order to keep it safe, they would have violated her strict demand for them not to touch her stuff. So in this way, they were essentially absolved of any liability having to do with her personal property. However, there was still that unlawful lockout, and whether that was ultimately responsible for her losses. And so my clients and I had to deal with that litigation both in the justice court and on appeal from the small claims court to the county court, where we ultimately resolve things by agreement. But yes, your tenants might make a claim if you elect some self-help remedy to try to fix things faster than the courts can do. In fact, if my clients had just gone the regular eviction route, they would have avoided the thousands of dollars they spent fighting this claim. Now, Ernie, you might be saying, I heard the law changed. I heard that a squatter can be put out just by submitting a declaration to the constable's office. And yes, this is true. There is a change in law that took effect September 1st, 2025 that says, among other things, if someone has entered unlawfully, they can be removed with a simple form that you deliver to the constables, where you swear to certain facts that the person who entered unlawfully. But that's where the conversation stops in this case. If you remember from the beginning, this particular couch surfer didn't enter unlawfully. She entered by permission. And because she did, the parties established a tenancy, not one where rent was exchanged. That's not what matters. What matters is that she was there because the landlord, in this case, the tenants, allowed a subtenant to come in with their permission, therefore making her entry completely lawful and prohibiting them from utilizing the new law that's, again, recently in place, wasn't available back then, but it wouldn't have helped them, even if it had been available, because she didn't fit that definition. Doesn't matter that she's there not paying rent. What matters is that she was able to enter lawfully, so she would have to be removed lawfully. Naturally, if you find yourself wrapped up with a complicated tenant or a situation that you are up to here with, but you're not exactly sure how to remedy that situation, sometimes your gut instinct is ultimately going to be your undoing. When you're looking to remove someone from your property, make sure you've at least consulted with an expert who can tell you if you're on the right path. Clearly, they knew a few of the steps. They knew about giving written notice. but they didn't know the consequences that would befall them by not following through with the eviction process. Just by setting a consultation and asking a few questions of a landlord-tenant attorney, you're going to get tons of guidance on how to avoid big problems from messy tenants. If you've learned something in today's video, I hope you give us a like, share any comments that you have, particularly of any times maybe you've tried some sort of self-help method that kind of blew up in your face. But if you're interested in doing even more learning on landlord-tenant law, there's a video right here with a ton of additional information for you to help you on your journey. Hope you enjoy it and all the rest of our content on this channel. And until next time, landlords, happy leasing.